Hello, everyone. Good afternoon and good morning, depending on where you are. And thank you for taking the time to join us today as we continue our 2024 webinar series. My name is Tina Barr, and I'm the Director of Training and Education for the National Association for Civilian Oversight of Law Enforcement. I do have to start before I go any further to let you know we have had a series of challenges since yesterday. And so the latest one is that we do not have the video for our presenter today. So we're trying to figure that out in the background. But given the weather and storms where our speaker is today, and power outages and a few hosts of other things, we're just happy to have you here and to be here. So although our presenter, we will not be able to see his video, you can see his slides. And so you also have a copy of the slides. I emailed those to you about less than an hour ago. So hopefully when we get to the post-webinar discussion, everything will be fine with the video as well as the audio. And so that way you can engage directly and see the speaker. So anyway, getting back to the introduction before we get started with the webinar. NACOLE is an organization that works to create a community of support for independent civilian oversight entities seeking to make their local law enforcement agencies, jails, and prisons more transparent, accountable, and responsive to the communities they serve. One part of that effort is our webinar series. Since 2015, NACOLE has worked to bring you information through our webinars on effective practices in civilian oversight, innovations in the field, and efforts to reform the criminal legal system. Before we begin, I'd like to start with a few logistics. First, everyone has the ability to turn on their captions by using the caption button at the bottom of your screen. Given the large number of audience members today, everyone has entered the webinar in listen-only mode. However, the Q&A feature is on, and so anytime you would like to type in your question, feel free to do so. To ensure that our speaker can get through all of the material that he has presented today, he will respond to questions at the end of the webinar, with the exception of questions that are asking for clarification about something that he's speaking on in the moment. In that case, I will let him know about the question and that it would be helpful to get clarification before we move any further. Please note, you will have the ability to upvote questions by clicking the thumbs up icon beside a particular question, and by doing so, that will move that question higher up in the queue. Given the limited amount of time today, that will help us address the most pressing questions. To allow more time for direct engagement and questions with our speaker today, immediately after the webinar, there is a 30-minute discussion scheduled. And so I will drop the link to that discussion into the Q&A feature so that everyone will have access to that, those of you who wish to join. Okay, so be on the lookout for that about 15 minutes before the end of the webinar, and I'll drop it in a couple times so you can have it. Finally, as a reminder, today's webinar is being recorded, and everyone who is registered for it will be the only ones who have access to it for 3 months following today. You will also receive a follow-up email with more information about how to access the webinar, the recording, within 3 business days of today. All right, now that those logistics are out of the way, I'd like to move our attention to the webinar, which is called or titled Constitutional Police Community Encounters. The webinar addresses foundational concepts and principles governing police community encounters, including reasonable suspicion and probable cause. Our speaker will examine the requirements for police to briefly detain and pat down community members, often referred to as stop, question, and frisk, the exceptions to the warrant requirement, and the rules which govern arrest. Presenting this information is Ashley Heiberger. Ashley is a retired police captain with several years of experience in federal oversight of law enforcement. He currently operates a consulting and expert practice focused on policy training, use of force, and accountability systems. Ashley's full bio is available on the online platform that you use to register for the webinar. So Ashley, on behalf of NACOLE and everyone joining the webinar today, thank you for being here to present, especially given some of the challenges you've encountered. I will turn things over to you now to get started.
Well, thank you, Tina. I appreciate that warm welcome. I also appreciate the invitation by NACOLE to offer this webinar. And I'd also like to thank everyone here who's taken time out of their busy day to join me for this conversation. That's my contact information. Feel free to call me or email me. I'm always happy to engage with NACOLE members around policing issues. So even if you feel that I'm wrong about something, please, I don't get upset when people criticize my perspective. So please feel free to contact me at any time. I have to begin with my disclaimer. Essentially, it says that nothing I say is legal advice. The handout, which you should have received, is not legal advice. You should not rely on anything I say or rely on the handout as legal advice. In short, if you want legal advice, you have to consult your lawyer, because that ain't me. A little bit about my background. As Tina mentioned, I currently have my own consulting and expert practice. I also hold 2 fellowships related to policing. The first at the Joseph F. Rice School of Law's Excellence in Policing and Public Safety program, and the other is with the Future Policing Institute. Also an adjunct professor, primarily for undergraduates and primarily at Moravian University in Bethlehem, Pennsylvania. I spent approximately 5 years as a senior policy advisor for Rosenbaum and Associates, assessing and evaluating compliance pursuant to federal DOJ oversight in Portland, Oregon. And finally, I spent almost 22 years with the Bethlehem Police Department in Pennsylvania. We're all here today to talk about constitutional police community encounters. Some of the topics that we're going to hit and our learning objectives are to increase our understanding about the federal constitutional perspective, the burdens of proof and the corresponding levels of intrusions, concept of investigative detentions, sometimes referred to as street stops or stop, question, and frisk. We're going to incorporate some exceptions to the warrant requirement. We're going to talk about arrests. And we're also just going to touch very briefly on a couple topics that pop up a lot in community member conversations. So let's get started. The Fourth Amendment to the federal Constitution, there's the text for you and the date of its ratification for you history buffs. You can see that that protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizure, and no warrant shall issue but upon probable cause. So that's some pretty significant language. As we understand the Fourth Amendment, it is a limitation on government power. However, it's not a complete limitation. It doesn't protect people against all seizures, only unreasonable seizures. Again, the Fourth Amendment is part of the federal constitution, and many states have similar provisions under their state constitutions. Here's an explanation that I think is a key concept we need to understand. We know that state and local governments also protect your civil liberties. They can provide more protection than the federal constitution, not less. Conceptually, we describe this as the constitutional floor because it represents the lowest possible level of protection. States and individual municipalities can offer more protection. They can have more restrictive policies governing their police activity, but they can't drop below that constitutional floor provided by the federal Constitution. There's some law professor language that essentially says the same thing, that states are able to offer more protection by having a more restrictive perspective under their own state constitution than the federal Constitution. Some very flowery language about that, less heralded than its federal counterpart. Our state constitution has often been interpreted to more broadly protect and supplement key fundamental rights and protections. And they make an excellent point here. They say this didn't happen by accident. This was intentional. The federal Constitution establishes a minimum, that floor that we discussed, to protect individual rights. But again, each state is free to offer greater protections. Here's an example of a state offering greater protections. Vehicle searches in Pennsylvania. I became a police officer in 1995, and from that time period up through 2014, Pennsylvania did not recognize the federal Carroll Doctrine. Carroll Doctrine simply holds that a police officer can search a vehicle once he has established probable cause and exigent circumstances. Under the federal view, the inherent mobility of the vehicle, the fact that the car can be driven away, is sufficient exigency to search that vehicle without a warrant. Prior to 2014, Pennsylvania did not feel that the inherent mobility of the vehicle was sufficient exigency. In other words, there had to be an exigent circumstance beyond the fact that the car could be driven away. That changed in 2014. Pennsylvania allowed officers to search under those circumstances, and that lasted up until about 2020, when the Pennsylvania courts decided they were going to go back to the previous perspective. So once again, Pennsylvania, under its own state constitution, puts additional restrictions on police that are not found in the federal jurisprudence. Here's a point, and I don't want anyone to get confused by this because it sounds like we're talking out of both sides of our mouths. I talked about the concept of the constitutional floor being established by the federal constitution, and states are able to offer greater protections. However, this is generally accepted, it's not absolute. Professor Miller and Professor Wright, in that article I've cited, they said it's easy to find state positions both above and below the federal constitutional requirements. So just know that this exists, know that it's not absolute, but don't get too concerned with it right now. For the purposes of today's discussion, we are going to say that the federal constitutional floor can be exceeded by the states. Additionally, individual municipalities, such as cities and towns, can provide greater protection by implementing additional restrictions on police. An example that's getting a lot of attention these days are limits on pretextual stops. Philadelphia implemented a ban in 2022. San Francisco followed up by 2024. Pretextual stops are clearly constitutional under the federal perspective. However, these are two examples of municipalities that are extending greater protections by increasing the restrictions on police. So again, the federal standard is the floor beneath which no state may fall, but states and localities can also offer additional protections. Because there's 50 states, and I have no idea how many individual municipalities in the country, it would be very, very impractical to address those individually. So for that reason, today our discussion is going to be limited to the federal constitutional standards. Here's a proposition upon which we can all agree. You saw what I did there, right? I hope so. We're talking about the federal perspective, and please understand that your state or your local standard may vary. So let's get started with a discussion about burdens of proof and levels of intrusion. In the larger sense, we live in a free society, and within our society, there are competing interests. They're equally valid. There's a tension between them. On one hand, we have the governmental interest in having their laws obeyed in the interest of safety and security. On the other hand, we have an equally legitimate interest of the people, of their individual liberties, to be able to move about freely, to go about their business without government intrusion. So courts must balance these two. They have to weigh safety and security against freedom and liberty. Once again, in a free society, there's always going to be some tension between these competing interests, and the courts are the ones that have to sort them out. Here's an explanation from Holtz, saying that whenever the police interfere with someone's life, liberty, or property, that counts as a seizure. We'll talk more about the specifics of seizures in a moment. But Holtz points out that the seizure is only valid when it's supported by a justification sufficient to balance the constitutional scale. Remember, constitutional balancing test, those weighing of competing interests. He goes on to point out that if there's a minimally intrusive investigative detention, that has to be justified with reasonable and articulable suspicion. If it goes beyond that to an arrest, there needs to be more justification. That has to be balanced with probable cause. And we'll talk in greater detail about both those concepts. Here it's broken down in a chart. On the left, we'll see the level of intrusion with the person's liberty, with their freedom of movement, and the corresponding burden of proof or level of justification that the police must have. The first level is a mere encounter, and that requires no justification on behalf of the police. An investigative detention must be justified by reasonable suspicion, and an arrest must be justified by probable cause. Those are the general rules, and let's unpack each of them in turn. Mere encounter is sometimes referred to as a mere conversation. I believe that's an Oregon term. It's also known as a mere inquiry or a request for information. We can see here some jurisprudence that holds officers don't violate the Fourth Amendment by approaching an individual on the street or another public place and asking them questions. And this emphasizes the voluntary nature of the interaction. Please understand the mere encounter does not require the person approached to answer the questions. They can walk away, they don't have to listen at all. So a mere encounter is not a seizure because it's non-coercive. An officer can approach someone with absolutely no justification and attempt to speak to them. The other side of that coin is the person being approached doesn't have to cooperate. They don't have to stop. They don't have to respond. In fact, they don't even need to acknowledge the officer's presence. Where it gets a little tricky is, what does the officer know? That's an interesting question in this situation. And I'm not talking about general knowledge. I mean specific information that may give rise to reasonable suspicion or probable cause. It can sometimes get a little murky because the person believes that they might not have done anything wrong, and they might be fully justified in that belief, but the officer might have information regarding them fitting a description or being in the area of a reported crime, or someone might have actually provided information that they could be engaging in criminal activity. But on the face of it, a mere encounter is not a seizure. The officer needs no justification, and the person approached does not need to cooperate. Let's move up one rung higher to investigative detentions. These are frequently called street stops, and they're the key component of a stop, question, and frisk program. We have to go back to prior to 1968. That time, police typically engaged in a practice known as field interrogations. It was common for officers to simply stop and search suspicious people. Not quite sure what constituted suspicious people, but that's what they did. Jones is a master of understatement when he says that these field interrogations were a major source of friction between police and minority groups. And he's brutally honest when he says that they were often undertaken with little or no basis for suspecting criminal activity. Interestingly, the courts didn't really say anything about this. They didn't authorize it, but they didn't say that police couldn't do it. So that was the state of the law up until about 1968. In 1968, the United States Supreme Court handed down a case called Terry versus Ohio, and it remains the state of the federal constitutional law. Detective McFadden from the Cleveland Police Department saw three men casing a store in the middle of the afternoon. He thought they were preparing to rob it. He approached the suspects. He identified himself as a police officer, asked their names, and obviously Terry was one of the individuals. Detective McFadden patted them down. Terry had a gun. The detective removed it and charged him with a concealed weapon. He moved to suppress the weapon. Trial judge denied it, upheld Detective McFadden's actions on a stop and frisk theory. The Ohio Court of Appeals affirmed, Ohio Supreme Court affirmed, and then the United States Supreme Court found that the officer's actions were proper and upheld Terry's conviction. So this Terry doctrine, if you will, gives rise to the state of the constitutional law today. An officer who wants to stop and question someone without their consent must be able to point to specific and articulable facts, which, taken together with rational inferences from those facts, collectively provides a particularized and objective basis for suspecting the person stopped of criminal activity. So keep in mind, we're talking about a stop. We've gone beyond a mere encounter. This is making someone stop without their consent. The officer has to have specific facts, and he has to have articulable facts. He has to be able to describe them. And the officer is also entitled to make rational inferences from those facts. And collectively, we're not talking about facts in isolation. We're talking about viewing the situation under the totality of the circumstances. This reasonable suspicion has to be particularized. Just because one person in a group might be doing something, another person in a group might be doing something, that doesn't give the officer reasonable suspicion for a third member of that group. And finally, it has to be objective. So when we're talking about these so-called Terry stops that are also described as investigative stops, ped stops, or investigative detention, the rule that still stands today is when an officer has reasonable suspicion of criminal activity, he or she can conduct a brief investigatory stop of the person. That's not all, though. There's another component to Terry, and this relates to frisking a person. Officers are authorized to conduct a limited search of weapons where they have reason to believe they're dealing with an armed and dangerous individual, regardless of whether they have probable cause to arrest the individual for a crime. See, that's further language explaining that we have not risen beyond reasonable suspicion. We don't have to have probable cause at this point. As it says, the officer need not be absolutely certain that the individual is armed. The standard is whether a reasonably prudent officer, under the totality of the circumstances, will be warranted in believing that their safety was at risk. So the so-called Terry frisk, also known as a pat-down or a protective frisk, that's based on the idea that when an officer has reasonable suspicion that the person stopped is armed and dangerous, the officer may frisk the person for weapons. The rationale for a Terry frisk is officer safety. That's the only reason it's justified. We're concerned with the protection of the officer and other people in the area. Again, here's some limiting language. It's confined in scope to an intrusion reasonably designed to discover guns, knives, clubs, or other hidden instruments. That always makes me laugh because I wonder exactly what types of instruments the court had in mind. Were they talking about trumpets? Were they talking about microscopes? Who knows? But the bottom line is Terry is justified for officer safety. Again, the basis is officer safety, which is why it is a limited search. It's a pat down of the outer clothing to look for weapons that could be used against the officer or anyone else in the area. A Terry frisk is not an evidentiary search. It's a limited search. It's not intended to discover evidence, allowing the officer to pursue his investigation without fear of violence, or at least violence that involves a weapon. So we also know that because it's an evidentiary search, the officer shouldn't be looking for non-weapon contraband. In other words, Terry frisk doesn't authorize an officer to go into someone's pocket looking for drugs. It's not an evidentiary search. You're not looking for non-weapon contraband. Now, here's an interesting point. In the real world, as a practical matter, day to day out on the street, the same facts and circumstances that create reasonable suspicion of criminal activity, which, as we know, is the justification for the stop, they will often create reasonable suspicion that the person is armed and dangerous, which is the standard that justifies the frisk. However, justification to stop is not justification to frisk. The stop and the frisk are very often closely related. However, we have to keep in mind they're separate tasks and they require distinct justification. Many times, the facts and circumstances giving rise to reasonable suspicion to stop will also provide reasonable suspicion to frisk, but not necessarily. It's not automatically. It has to be distinctly justified. It's a two-step process. The officers have to develop reasonable suspicion to stop the person and reasonable suspicion that they are armed and dangerous. That second step is often very small. Sometimes it's a baby step. It can't be skipped. Officer has to engage in both steps of that process. To be able to stop a person requires reasonable suspicion of criminal activity, and to frisk them, to perform that limited pat-down, that search for weapons, they have to have reasonable suspicion that the person stopped is armed and dangerous. Remember, that's a two-step process, and both steps have to be completed. Reasonable suspicion is somewhat abstract. The Supreme Court tells us that they intentionally didn't give us a neat set of rules. Like I said, gee, thanks, that's not particularly helpful, but at least they're acknowledging that it's abstract. Reasonable suspicion is developed through a process. Officers bring their education, their training, and their experience as they investigate, as they gather information. They learn specific and articulable facts. As we heard a few minutes ago, they're also able to make rational inferences from those facts. Those rational inferences may or may not establish reasonable suspicion, but the officer is entitled to use their education, training, and experience as they conduct their investigation, gathering that information, looking at rational inferences from those facts to see if there is or is not reasonable suspicion. Reasonable suspicion is more than a gut feeling. Again, the Terry Court emphasizes specific and articulable facts, rational inferences, collectively provides particularized and objective basis. It's not just a gut feeling. It's not just a hunch. The court says very directly, we're not going to give any weight to unparticularized suspicions or hunches. Specific reasonable inferences are required. And here, I think it's interesting, the court acknowledges that an officer's experience counts for something when they're evaluating a situation. So we know that reasonable suspicion goes beyond gut feelings, goes beyond hunches. It's not generalizations or subjective opinions. However, it's not as high a standard as probable cause. This is a very interesting point about reasonable suspicion, and this is one that occasionally causes some difficulties for community members. At this point in the analysis, the officer is not required to rule out the possibility of innocent conduct. That means if a person is engaging in behavior that could be entirely consistent with innocent conduct, could also be consistent with criminal activity, the officer is not required to disregard the possibility of innocent conduct. The officer is able to point to specific and articulable facts that says this behavior was consistent with criminal activity as well. I have reasonable suspicion to conduct a brief investigatory stop. Sometimes people who know that they have not been doing anything unlawful, they're kind of troubled by this, but this is the guidance that the Supreme Court has given us as they try to balance the scales of what level of justification matches up with that level of intrusion, balancing those competing interests of public safety and security against freedom and liberty. So keep in mind that whether you like it, don't like it, agree, disagree, at this point in the analysis, officers are not required to rule out the possibility of innocent conduct. The analytical framework for the officer in this situation is the totality of the circumstances. Holtz tells us that when there's an innocent explanation with one fact in isolation, put that together with some other facts, you now have reasonable and articulable suspicion. Think of it this way. We all pretty much understand that a brick doesn't make a wall, just like one fact doesn't make reasonable suspicion. However, if you put together a couple bricks with a couple more bricks, you will eventually have a wall. It's the same thing with facts. You put one fact that's innocent in isolation with another fact, another fact, another fact, it can often lead you to reasonable suspicion. A brick is not a wall, but you put together enough bricks and you'll have a wall. So, summarize this. Reasonable suspicion of criminal activity justifies a brief investigative detention, known as the Terry stop. Reasonable suspicion of being armed and dangerous justifies a limited search, the Terry frisk, which is a pat down of someone's outer clothing for weapons. This is just my opinion. I throw it in here. I understand that not everyone is going to share it. I understand that some people will adamantly disagree. And that's okay, because the world would be a pretty boring place if we all thought exactly alike. For what it's worth, here are my 2 cents. When it's used within constitutional parameters, when it's being done lawfully, stop, question, and frisk is a valuable tool. Criminal law enforcement, as well as officer and community safety. Here's the caveat. Agencies and individual officers have to be judicious when they're applying it out on the street. In my view, stop, question, and frisk is a scalpel, not a chainsaw. So what's an arrest? Holtz has a pretty good definition. It's concise, and I think it covers everything we need to say. It's a substantial interference with the liberty of a person. It goes beyond that brief investigative stop, that investigative detention. It's one rung higher on the ladder. It is a substantial interference. It results in apprehension and custodial detention. So I think that's a very concise definition of an arrest. We need probable cause to arrest. The Fourth Amendment tells us that no warrants for arrest shall issue except upon probable cause. Another case that reiterates it, arrests are unreasonable unless supported by probable cause. The constitutional justification for an arrest is probable cause, regardless of whether we're talking state or federal, regardless of whether we're talking with or without a warrant. The justification for arrest is probable cause. What is probable cause? Well, the United States Supreme Court says we have probable cause where the facts and circumstances within an officer's knowledge and of which they have reasonably trustworthy information are sufficient in themselves to warrant a belief by a man of reasonable caution that a crime is being committed. So we have some limiting language there. Reasonably trustworthy information and a belief by a man of reasonable caution. As I mentioned earlier, probable cause one level above reasonable suspicions. And I think this language is helpful as well. Reasonable suspicion and probable cause are not able to be precisely articulated or defined, but they're common sense, non-technical conceptions that deal with factual and practical considerations of everyday life on which reasonable and prudent men, not legal technicians. So even though we don't have mathematical precision in this regard, this guidance from the court tells us, hey, we're not sitting around as lawyers, as law professors, as legal scholars, talking about everyday people living in the real world with factual and practical considerations. Common sense, non-technical. Holtz tells us that probable cause exists when the facts and circumstances are sufficient to permit a prudent person or one of reasonable caution to conclude that there's a fair probability that a criminal offense is being or has been committed, and the suspect is or has been a criminal participant. So once again, we see that cautionary language, a prudent person, one of reasonable caution, a fair probability. This case sums it up very, very concisely. Probable cause exists when an officer can articulate facts that indicate a person is involved in criminal activity. I think that's a great definition of probable cause. Information that will lead a reasonable person to believe that a crime's been committed and the suspect probably committed it. Probable cause is a flexible, common sense standard. Here's an interesting point. Probable cause requires only a probability or substantial chance of criminal activity, not an actual showing of such activity. Keep in mind that the officer does not have to be right at this point. It only has to be reasonable. Assuming that we have justification, that there is sufficient probable cause to arrest someone, the officer is able to conduct a search of the arrestee's person. This goes beyond the Terry frisk. This goes beyond that pat down. This is a full-blown search incident to arrest. It's done when the person is taken into custody. The rationale is it protects the safety of the officers and others nearby, and also allows for the preservation of evidence. Again, the search incident to arrest is a full-blown search. It goes beyond that limited search in Terry. Another point about the search incident to arrest: if you're justified under the Fourth Amendment in arresting someone, if you have probable cause, you don't need any additional justification to perform that search incident to arrest. The court has said that an arrest on probable cause is a reasonable intrusion. If that intrusion is lawful, the search doesn't have to go any further with regard to justification or burden of proof. Make no mistake about it, the arrest itself has to be valid. You can't justify the arrest with the search. You can't justify the search with the arrest. You can't bootstrap that way. A search incident to arrest is limited to the arrestee's person and the area within their immediate control, their wingspan, if you will, the area from which they might have grabbed a weapon or evidence. So what this means is, if you arrest someone in the kitchen or the living room of a residence, the search incident to arrest does not authorize the officers to go upstairs and search the bedroom or the bathroom. The order isn't particularly important so long as probable cause for the arrest existed and you were not relying on the search to uncover evidence to produce that probable cause. In this case, the court said, when the formal arrest follows so quickly on the challenge search of the person, we don't believe it's particularly important that the search preceded the arrest rather than vice versa. This is the key point here. As long as the results of the search were not necessary to give you the probable cause to arrest. In other words, you have to have the probable cause to arrest before that search is conducted. The fruits of that search, or what you find when you search the person, do not give you the justification to arrest. Again, they say it again, this is Holtz talking about the probable cause has to exist prior to the search. As long as that probable cause to arrest is present prior to the search and does not rely on the search, it doesn't matter if the search comes first. This comes up a lot. People often ask this. The Supreme Court has been very clear on that. Unless the police have a warrant, they cannot go into a cell phone and take information out based on a search incident to arrest. The courts have recognized that people feel very strongly about the information contained in their phones. They recognized a greater expectation of privacy with regard to the phones, as well as the fact that a phone can't be used as a weapon. So the rule here from Riley is that police need a warrant to search a cell phone. It's not authorized based solely on the arrest. We'll talk about two concepts here that can be similar, and they're sometimes confused within the eyes of community members. So we're going to do our best to unpack them here today and differentiate between the two of them. First is emergency aid, and the second is community caretaking. Emergency aid is a doctrine that says Police can make a warrantless entry to render emergency assistance to someone inside who might be injured or to protect someone from imminent injury. The caveat is that police's belief that emergency assistance needed must be objectively reasonable. In other words, you can't want to get into the house for some other reason and try to use this doctrine. The belief that someone needs help has to be objectively reasonable. This typically comes to play where people are believed to be injured inside a home, or there might be a domestic violence incident going on, and the officers believe that it's necessary for them to go in and protect someone. Here's some language. When policemen, firemen, or other public officers are confronted with evidence which would lead a prudent and reasonable official to see a need to act to protect life or property, they are authorized to act on that information, even if ultimately found erroneous. So once again, the court is giving police, and here firemen as well, giving them some leeway. You don't have to be right, you just have to be reasonable. Community caretaking is a little different. Community caretaking functions described by the court as being totally divorced from the detection, investigation, or acquisition of evidence relating to the violation of a criminal statute. The facts of Cody versus Dombrowski are pretty interesting, and I'll share them with you here. Dombrowski was a Chicago police officer who got into a traffic crash while he was in Wisconsin. Apparently, he was intoxicated, and the police in Wisconsin were concerned that his service weapon might be somewhere within the vehicle. They searched the passenger compartment, they searched the glove compartment, did not locate the weapon, so they checked the trunk, and in the trunk, they discovered evidence that connected Dombrowski to a murder. That evidence was able to be used against him because the police were not performing an evidentiary search. They were engaging in this community caretaking function, trying to protect the community from having an unsecured firearm in a vehicle. So emergency aid and community caretaking can sometimes have similarities, but they are two separate and distinct doctrines. Interestingly enough, when it comes to community caretaking, the court draws a bright line. They make a clear distinction between vehicles and homes. The court will not support a warrantless search or seizure in a home under the community caretaking function. What happened in this case was there was an individual inside his residence with his wife. He was in some mental distress. He set a firearm on a table and told his wife just to shoot him. She called the police because she wanted him to get some mental health assistance. When the officers arranged for an ambulance to come, he was taken away. They secured his firearms, and ultimately the court said that they did not have the authority to do so under the community caretaking function. The court made that bright line distinction between the vehicle that we saw in Katie versus Dombrowski. Here they said, you're not doing that inside a house without a warrant. This question tends to come up a lot. People often ask about the court's stance on this. It's pretty clear. In the Mims case, the Supreme Court said police can order the driver of a lawfully stopped vehicle out of the car for any or no reason. Then similarly, the same issue when it comes to passengers. Police are able to order the passengers of a lawfully stopped vehicle. So those are the sites for the cases that we discussed in case you'd like to look at them yourselves. The other materials that I mentioned, you can see Holtz's book, Jones's article, Macron and Solari, we just had some quotes from. So now, questions, comments, concerns? Anyone like to talk about anything that we brought up here?
Well, it's me, Ashley. People are not able to talk since we've got the webinar in webinar mode. However, there are some questions that have been posed in the Q&A function. Um, if you click on the Q&A feature at the bottom of your screen, Ashley, you'll see 3 questions that are in the queue. And let me know if you can see those.
Okay. Yes, I do.
Okay.
It looks like, can everyone see them or should I read it?
Everyone has the ability to see them.
Okay. Regarding the first question about training to establish reasonable suspicion, um, with regard to warrior style training, um, we can have a conversation about warrior style training, go on all afternoon here. My immediate thought in response to that question is the reasonable suspicion analysis, I think, deals a little more with legal authority or legal justification to make that stop, to make that uh, frisk. And again, if I didn't convey this properly, I'd like to emphasize it. You know, that reasonable suspicion is a relatively low burden. So I don't know how much the warrior training would have an effect on reasonable suspicion analysis. Uh, I don't know if that answer helps you, if I'm really answering your question. If not, let me know because we're going to move on to the second question. I suppose that there could be some risk to considering probable cause a common sense concept. And you raise an excellent point that what's common sense to one person might not be so commonsensical to another. However, I think the court is to acknowledge, and they do acknowledge, the fact that officers are required to make these assessments, to make these decisions every day in the real world. They don't have the seemingly unlimited time that we do later to go back in hindsight and look at every nuance. So I think the court is acknowledging the fact that officers have to make these decisions routinely and in relatively short periods of time. They don't have the luxury of reflection that we do after the fact. And the other thing that I think relates to that is the fact that the officer is not required to rule out innocent conduct. Well, and kind of a no blood, no foul kind of thing. If the officer uh, stops someone based on reasonable suspicion and there turns out to be, no criminal activity, well, yes, the person was detained, but the courts view that as a minimal intrusion. If the officer establishes probable cause and later investigation reveals information that clears the person of involvement in the crime, or persons prosecuted and they're acquitted, the ultimate result of the case, the outcome of the case, doesn't have any bearing on whether or not there was probable cause to make the arrest. Again, reasonable suspicion and probable cause are very, very early on in the process. So the police are given a fair amount of leeway. Uh, Moving on to the next question. Does the emergency aid standard apply to mental health calls for emotionally distressed persons? I think the emergency aid standard focuses on the ability to enter a home rather than the type of distress, the particular distress. I don't think the emergency aid doctrine differentiates between whether it's a medical issue physically, a medical issue emotionally, or someone needs protection from an imminent injury. To what extent is emergency aid differentiated from specific protocols for answering calls for emotionally distressed persons? I think there might be some overlap there, because if you have an individual who you believe needs that emergency assistance, I would imagine that your specific protocols for answering that type of calls, they're going to take into account the officers need to gather information to find out exactly what's going on with that individual to determine whether or not to make entry. So I think there's pretty significant overlap there. Next question, how does the recent Supreme Court ruling regarding domestic violence removal of weapons from a household apply? Not sure exactly. Are you referring to the case that just came down where the Supreme Court said that someone who is under a domestic violence protection order is prohibited from possessing firearms? If that's the case, I would imagine that, each state is going to have its own particular process based on whether or not officers are able to make a warrantless entry into a home to remove those weapons. Even looking back at my own career, because in Pennsylvania, there's a state prohibition that persons under protective orders were not authorized to possess firearms. And most of the time we ended up having to just do a workaround. I'm not sure how that's going to play out. Can we speak to the role of drug detection dogs in establishing justification for the search? Let me just allow me one moment here. I'm going to get you that case name if I can, because the Supreme Court has ruled on dog sniffs. I don't have that case name in my head, but give me one moment here and I will pull it up for you. Yes, Illinois versus Cabales. It's at 543 US 405. It's a 2005 case. The United States Supreme Court determined that the Fourth Amendment does not require the police to possess reasonable articulable suspicion to justify using a drug detection dog to sniff a vehicle during a legitimate traffic stop. According to the court, a dog sniff conducted during a lawful traffic stop that reveals no information other than the location of a substance that no individual has any right to possess does not violate the Fourth Amendment. Now, keep in mind that there's also a number of other issues that come into that, where the qualifications of the dog, how it was trained, the time in which it takes if the dog had to be brought from somewhere else. So a lot of different things going on with drug detection dogs, but I believe that's the controlling case with respect to your question. Yes. Yes. Good. Okay.
Hey. So those are all of the questions. You've responded to all of them that were posted. And so that is perfect timing. For those of you who would like to join us in the discussion where you can actually see Ashley and directly speak with him rather than going through a Q&A feature or a chat feature, you can actually speak directly to him, then the Zoom link is posted in the chat, the one-way chat. And so I'm going to give you all enough time, a few minutes. For those of you who want to join the discussion, you can click the link and that will take you directly to the Zoom room, the Zoom discussion link. Sometimes a couple of you last month were asked for meeting ID, but most of you were not. So if by some chance you are asked for a meeting ID to enter the Zoom, then I've posted it there in the chat for you. And so, Ashley, before I wrap things up here, is there anything else that you would like to say about this topic? Anything at all?
Oh, again, we were kind of at a slight disadvantage because we only had about an hour and we could barely scratch the surface. They hold symposia on these issues that last for days, sometimes as long as a week. But again, my contact information is there. If anyone would like any clarification or further discuss anything that we talked about, please feel free to reach out, even if it's just you calling or emailing to tell me how wrong I am.
That's very generous. The PowerPoints were sent less than an hour or about an hour before the webinar. So if you have not yet checked your email, you will have the ability to download these, the PDF version of the PowerPoint. So just a couple of announcements before we go. The next webinar is scheduled for the end of July. I'm in the process of getting the information posted on the website about that. And it's about the intersection of justice and policing by some folks in Philadelphia who will be doing the webinar. The annual conference registration is open and early registration ends on August the 2nd. Last year, we had to close registration early because of the numbers that we were getting registering. And so please register as soon as you can, just in case we have that much of an interest similar to last year. We would hate to shut things down without everybody getting in who wants to. And so also a reminder, we do have a conference scholarship application process for people who would like to attend the annual conference, but might not have the funds, or your office doesn't have the funds to do so. So the scholarship application information is on the website, as well as all of the conference information. And so the deadline for that scholarship application is July the 8th. Okay. So thank you all for attending and your time. Thank you, Ashley, for your time and weathering the storm, literally and figuratively. And for those of you who would like to join us in the discussion, I'm going to keep this up for about 30 more seconds to a minute. And then Ashley and I will see you there. For those of you who are not able to attend the discussion, thank you for joining us. And everyone will receive a follow-up email with instructions on how to access the recording, which will be available to everyone who's registered, to you all only for 3 months from today. So thank you, and we will see you in the Zoom room or the next webinar. Ashley, I want to make sure that you get this link too for the discussion room.